First of all, welcome everyone to this OxBHR event on business, human rights, and climate litigation. My name is Danilo. I'm one of the student organizers of OxBHR, which is a project entirely student-led from the Bonavero Institute at the University of Oxford. And today I am more than happy to be joined by three of the leading voices, both in academia and in practice, in the field of climate litigation. And I'm sure you'll also agree with me once you've heard from those three amazing women. First of all, just to give a brief overview of what we'll be covering today. So in recent years, courts across the globe have witnessed a boom in climate litigation cases brought not only against states, but also corporations. For instance, in Milieudefensie and others, and Royal Dutch Shell PLC, Dutch courts found that companies can be held civilly liable for their contribution to climate change and advanced the law when recognizing that the UNGPs, the United Nations Guiding Principles, can be used as a source to interpret obligations arising from domestic law. But even when successful, are rights-based claims and litigation beneficial to climate objectives? How can unintended environmental and human rights consequences from litigation be mitigated? And what broader trends can be identified in the case law on corporate responsibilities related to climate change and human rights? So these are some of the questions that we hope to spark in this debate. And to start with our discussion, I am very happy to introduce a fellow Brazilian, Dr. Joana Zetzer, who I'm sure you have heard before. Joana is an assistant professorial research fellow, at the Grantham Research Institute on Climate Change and the Environment at the LSE. And she's certainly one of the biggest names in climate change, with a amazing publication record in the area of climate litigation as well. So without further ado, Joana, the floor is yours.
Thank you so much, Danilo, and very happy to have fellow Brazilian at Oxford doing wonderful work, PhD, and now we heard the good news, many more good things coming on the way. So thank you for this invitation. Thank you for also the other panelists for being part of this. What I want in my short presentation, it's going to be a 15-minute presentation, is to give this big picture of rights-based climate litigation. And I'm speaking to probably people who are very familiar with the issue of human rights. What's interesting here is that we are talking about how the climate justice movement is using human rights and how this continues to grow. You might have seen just last week on Friday, the Human Rights Commission of the Philippines released its findings on this really path-breaking inquiry that they carried for a few years on the responsibility of the carbon majors for human rights associated with the impacts of climate change. So it's a field that already saw a lot, and it's still, I would predict, going to see more. So let me begin. And what I want to do in my presentation is basically four things. First, I want to start with outlining the rise of rights-based climate litigation. Second, I want to emphasize a few trends. Thirdly, very briefly present a typology of rights-based litigation against states and against corporates. And I want to finish with this idea of just transition litigation. All of this and more you can find in this paper that Annalisa Savarese and I published also a few weeks ago. It came out on the Journal of Human Rights and the Environment. It's as from very recently open access. So I encourage everyone now, you can find the paper and download it for free. And we also wrote a few blogs about that. Very well. So let me begin with the presentation. And of course, you can understand this movement of rights-based climate litigation in different ways, starting in different moments. But it's fair, and the literature has already written about that, that it starts in 2015, very much with a case that, who would know it would be so important, but a case brought in Pakistan, the well-known now Ligari versus the Federation of Pakistan, that really made history by when Justice Ali Shan accepted the arguments that the governmental failures to address climate change were violating the rights, the human rights of the petitioners. This was 2015. In 2018, Jackie Peel and Harry Ozovsky published their well-known paper, A Right's Turn in Climate Litigation. And what Annalisa and I tried to do was to think, okay, so in 2018, they thought there was going to be this right's turn. First, can we say that that right's turn occurred? And what can we say about this right's turn? So what we did, we identified in the databases of climate litigations that you probably know that we maintain with the Sabin Center and at the Grantham, we identified all the rights-based cases that we could identify. And I don't know what your guess would be. Maybe you already read the paper, but we identified 112 for the paper, 112 cases that were rights-based climate litigation. And what we also saw was that the prediction that Jackie and Harry made was quite correct. So in 2018, they saw that right's turn, actually over 2/3 of the cases were filed after 2018, between 2018 and 2021 when we were looking. So really the turn materialized. What we did in the paper was then, let's look at these 100 and something cases and understand what is that big picture. What we noticed very quickly was that those cases are the majority of them were cases that are climate aligned, which is part of the story. So we did the mapping of those, but in identifying that that was only part of the story, we also tried to do this initial attempt, at least, to say, what about the cases that are not aligned with climate objectives, that are rights-based, and what can we say about those? So these are the just transition cases that I will also briefly mention. Okay, so I don't want to go too deep into definitions, but it's useful to remember that rights-based climate litigation is it's a part of what climate litigation is now, which is quite a big picture of many different areas of law in which these cases engage with. So you have cases dealing with planning and administrative law and commercial law, civil, tort, criminal, consumer protection law. Rights-based sometimes overlaps with these, and most of the times I would say overlap, but it's a very diverse group of cases. So the way we have been defining is that these rights-based litigation is litigation that raises questions of law or fact regarding climate science, mitigation, adaptation, and which rely in whole or in part with human rights. You can find the cases on our Grantham and Sabin databases, Sabin for the US, non-US, Grantham for non-US, and we built a special spreadsheet to do this specific analysis, which if you're interested, I can also share. So now some of our findings. I said I was going to talk about the trends. First, in terms of the numbers and the chronology, it was interesting to see how general climate litigation has been growing constantly since pretty much 2005. Especially after 2007, 2008, but it's growing. Rights-based climate litigation really starts in 2015, and then it just shoots up. And so this is the first thing. It's more recent, and you can see that in the graphs we have in the paper. More interesting than that, I find it's the geography. So if you look at all of climate litigation, you have that huge bar of climate litigation in the US, vast majority of cases, 1,500 cases in the US, and then the rest of the world. Africa, you hardly see in the bars. Latin America, small. So it's international cases, quite small. Focus on the rights-based, the figure changes completely. So the majority of cases in rights-based litigation has been filed in Europe. So that's already something to note. And then you can see in this comparison that actually Africa and South America and international cases respond for a much more significant chunk of the data. The last trend that I want to mention here is one that I also find particularly interesting, because you would think, well, probably the reason why we see this increasing number of cases of rights-based is because you have a better chance of winning, right? Bring a rights-based case and you have a agenda story, which might still be true in the near future. But what we saw in the paper is that actually, if you compare to, and mostly non-US, but anyway, even without comparing, the majority of the decided cases, again, very few cases have been decided, but the majority of the decided cases have been unsuccessful. So in the paper, we have, I think, 56% of cases unsuccessful, and then 44% successful. So that was an interesting finding also that you have in our paper, and there's more detail there. Again, remembering, it's important to remember that most cases are still ongoing, and second, that strategic litigation is not just about the final outcome, it is about the process, the awareness that is raised during the case, before, during, even after, even if you lose. There is also a lot to be said about impacts in there. So a whole different story. Okay, good. So this is general trends. Now I want to briefly talk to you about the typology of cases that we developed. And in the paper and in the blogs, you see we have this tree of typologies. What we did in our work was that we divided the litigation, the rights-based litigation, in litigation against states and governments. The litigation against states, we divided into the substantive and the procedural ones. And the majority of cases, we had 93 cases against states, 79 were on substantive grounds, and 14 on procedural grounds. So you really see how so far strategic rights-based litigation has been mostly on the substantive type. And the majority are asking for positive obligations. So here you have, for example, agenda type cases where asked for adoption of legislation, or the legare case type asking for the enforcement of legislation. But we also have cases against states that are seeking a negative obligation. And it's interesting because there were 30 of such cases that are seeking a remedy that is to refrain from harmful activities. And one of the examples that we could mention there is the case in Norway. Then if you look at the procedure ones, most of the cases deal with access to information. So we have, for example, the cases filed against the Irish government seeking information in the approval of the expansion of an airport, and other cases, very few that deal with access to participation, which is quite different from what you see in overall environmental litigation. Now, from rights-based litigation against the states to rights-based litigation against corporates, this is where it's really also very interesting to see what's going on, because it's not, to begin with, not obvious that you would bring a rights-based litigation against a corporate, because as a general law, rule, corporates don't have human rights obligations. And so what we see here is that we found 16 cases, if I'm not mistaken, of cases yes, 16 cases filed against corporates, 14 of those substantive obligations, the majority of the negative type, so seeking corporations to refrain from harmful activities. And an example here is also the one I just mentioned, the Philippines investigation of the carbon majors. But we have, of course, positive obligations to reduce emissions, such as the Shell case, and also in terms of supporting policies that are climate aligned. The procedure cases were very few. We only found 2 of such cases, and both have been filed before the OECD focal points. One of them in Japan, dealing with the financing of coal, and another one which was a Polish case that dealt with information concerning the corporate emissions and the financial impacts of ensuring coal mining in Poland. So that's the big picture of what we know about climate litigation based on human rights. And I want to finish this short presentation talking about what we don't know. So what Annalisa and I identified is that there is a significant gap in our understanding, both in terms of collecting cases, so in data, and also in analysis, and also how much we talk about cases that are not aligned with climate objectives, but are brought to protect human rights. So we call these papers in our paper, we call these cases just transition litigation. And we distinct these from what the climate litigation literature usually calls anti-regulatory or defensive or anti-climate litigation in general, because those are cases that are brought with the aim to challenge climate action. And what we are saying is that many of these just transition cases are not aiming that. they are aiming to protect human rights, but not necessarily to undermine climate action. And a few examples are rights-based cases associated with indigenous peoples, and we see a few examples in Mexico, also dealing with reduction of forest emissions, construction of hydroelectric dams. So many cases also that we've seen as environmental cases in the past, but that have considerable impacts in climate action, and that now some of them are also being framed in climate terms, could fall into this category. And then once we identify these and we used a database of cases that is maintained by the Business and Human Rights Center, we didn't do the same in-depth analysis of types, but we could do an initial mapping. We mostly focused on exploring what does it mean, where does it leave us, and what type of research agenda this creates. So the first point, and I will finish in a minute, is that this type of phenomenon is not a surprise. It is a reflection of the changes in the status quo that is needed to address climate change, but that also means new equilibria between different societal interests. Also, the fact that this rise in just transition litigation is probably going to be still seen, and it emphasizes really the importance that both states and corporates can safeguard procedure and substantive rights. Otherwise, it is likely that cases will end up in courts, and this is, I guess, what we should try to avoid. So to conclude, there is a need to explore this new frontier of not only the rights-based litigation that will continue to grow, that is aligned, but also of the just transition litigation, to hopefully understand better what governments and corporations can do to address climate change, deliver net zero, but at the same time enact an energy transition that is inclusive and that is in line with human rights. So I stop here, and I'm looking forward to the next presentations and the Q&As.
Thank you very much, Joanna. Sorry. Thank you very much, Joanna, for the great presentation, for all the efforts that you made to be here with us. It's really appreciated. Now I would like, just before introducing the next speaker, to remind participants, if you have any questions, to please use the Q&A function. And then at the end, we will have an opportunity to have a Q&A session with the panelists. That being said, it is also my pleasure to introduce the next speaker, Charlotte Hanson. Charlotte is currently Master of Public Policy candidate at the Oxford University's Blavatsky School of Government. So she's a colleague of mine, which I'm very happy to say. And her career has centered around climate law and climate policy. She has worked with the leading Australian environmental law judge, the Justice Brian Preston, and is now a lawyer as well at Client Earth, who has co-speared a number of very important climate cases and environmental cases in general. She works on the energy systems part as a lawyer in Client Earth, and she will speak to us a little bit about the NGO role in this area. So Charlotte, the floor is yours.
Thanks, Danilo, and it's fantastic to be here with you all and joined by this amazingly eminent panel of speakers. I feel very honoured to be here. So I'm going to talk you through some of the challenges I've experienced in bringing legal interventions against corporations in my role as a lawyer for Client Earth. And by way of background, sorry, Danilo, are you able to get the slides up as well? Yeah, thank you. By way of background, Client Earth is Europe's largest environmental law charity. We have over 200 staff working on climate, nature, chemicals, forests, and a lot of other issues in over 50 countries across the world. And my work focuses on the problems of greenwashing, misreporting of greenhouse gas emissions, and how governments regulate GHGs. But given the focus of today's talk and my talk specifically on bringing legal proceedings against corporations, I'll start by discussing some of Client Earth's recent cases against companies with a particular focus on greenwashing. I'll then outline some of the challenges that public interest climate lawyers confront in relation to legal interventions against companies. And then I'll talk about some of the considerations that we take into account in deciding which cases we should pursue. The legal interventions that I'm discussing here aren't grounded in human rights, but they do illustrate strategic considerations that are relevant to climate and human rights cases. So I hope you can find this relevant as well. But first, I just want to briefly explain what greenwashing is in the context of fossil fuels. So I'm referring here to advertising by a company about its environmental or climate credentials that creates a distorted impression of that company's current and or future business model and business practices. So we're seeing, I'm sure many of you will recognise this, we're seeing a total proliferation of greenwashing everywhere, including with companies making claims about their capacity to meet net zero emissions by 2050. That's so much so that the Secretary General of the UN has actually declared a second climate crisis to be emerging, which is one of mistrust, which includes this problem of companies claiming that they're net zero compliant. Two cases that give a sense of the work that Client Earth is doing are the actions we're bringing, or the actions that we're involved in against Shell, which is different to the Dutch court proceedings, and against Total Energies. So for Shell, in March this year, Client Earth started a first-of-a-kind legal action against the board of Shell, seeking to hold the company's directors personally liable for failing to properly prepare the company for the energy transition. And Client Earth's lawyers and the UK lawyers that we have engaged, which is Palace Partners, are arguing that the board's failure to adopt and implement a climate strategy that truly aligns with the Paris Agreement is a breach of their duties under the UK Companies Act. Under that act, Shell's board is legally required to act in a way that promotes the company's success and to exercise reasonable care, skill, and diligence. Our lawyers argue that those requirements require directors not to prioritise their near-term profit over the enduring viability of the company. On the Total matter, Client Earth is supporting a coalition of environmental groups, which is bringing an action against Total Energies in the Paris Judicial Court, challenging alleged greenwashing under the Unfair Commercial Practices Directive of the EU, which prohibits misleading and deceptive practices. Some of you might have seen Total Energies' huge marketing push in recent years, which includes claims that the company is committed to being a major player in the energy transition as part of it achieving carbon neutrality or net zero by 2050. And it's announced those aspirations ahead of its recent rebrand from what was Total to now Total Energies. The coalition of environmental groups are arguing that Total's advertising to French consumers is deceptive and that it gives a false impression of the company's so-called net zero plans. These plans are actually include a massive fossil fuel expansion, which clearly conflicts with what climate science is telling us is needed. And it also avoids any action to meaningfully reduce emissions in its operations by 2030, which is also required. So these two cases both highlight the increasing creativity that we're seeing in public interest climate law, where lawyers are making use of a wider toolkit of enforcement options beyond specific environmental and climate laws. So corporations law and consumer law, as well as human rights, as discussed by the other panelists, are particularly important in that regard. Can we go to the next slide? Yeah, thank you. So moving to challenges, I want to highlight two types of challenges that arise in bringing action against companies. First is relating to resources and second is relating to evidence. In terms of resources, there's a major enforcement gap when it comes to a lot of climate issues, including greenwashing, but also in other areas. So we can identify considerably more unlawful practices than we have the resources as public interest lawyers to legally challenge. And not only are NGOs limited in the quantity of cases that they can bring, but sometimes also by standing issues. So some actions can only be taken by shareholders, which would require then that we do have people that we can incorporate into challenges that are shareholders, which is another sort of process that takes time, or they need to be beneficiaries of a given financial service, such as sort of members of a superannuation fund, pension fund, or for energy related claims, they often need to be energy market participants, which NGOs generally aren't qualified as. And given those constraints, it's important to identify iconic cases, which are cases that can attract significant publicity, but also have high strategic value. And they also need to have they do need to have reasonable prospects of success. But there's a bit of a weighting exercise involved there where I think different NGOs take different approaches in terms of to what extent it's strategic to bring an action, even if the prospects aren't as good. And we have considerations in Client Earth around even jurisdictionally specific sort of prospects. So there's certain cases where it's very important to kind of maintain a very strong record of succeeding in front of the courts, so that we can kind of maintain our reputation and make sure that that we're able to sort of access the system in a helpful way going forward. So yeah, there are sort of nuances to the way that we assess which cases are worth bringing and how successful they're likely to be. And we're also often looking for alternative ways to bring cases in forums that are outside of traditional courts. So for example, in 2019, Client Earth brought a complaint against BP under the OECD guidelines in relation to BP's alleged greenwashing, and that was quickly followed by BP announcing an end to its reputational advertising campaign. So in terms of moving on to evidence, there's often a structural information asymmetry between public interest litigants and companies, which regulation has an important role in addressing. An example that I'm often confronted with working in the energy sector is with respect to methane leaks through the energy supply chain. So methane is a very potent greenhouse gas, which is very often leaked through coal, gas and oil supply chains and causes a lot of damage to, in terms of climate harm. We can see that energy sector emissions of methane are higher than is being reported, and we can often see physical evidence of methane leaks, but it's very difficult, or in some situations impossible, for NGOs to rigorously quantify what those leaks are and bring challenges on that basis. Regulation could address this by making reporting requirements more rigorous and providing open access to data, and that would enable public interest groups to act as an additional enforcement agent. But without a supportive regulatory environment, legal interventions that use creative methods of enforcement have a really important role. I think an ideal case in that context would be one that holds the relevant company to account, but also prompts governments to regulate, which would in turn reduce the need for third-party enforcement. And can we go to the next slide, please? In terms of strategic selection of cases, in addition to identifying iconic cases, it's important to also focus on ones that can create systemic change. Client Earth and many other public interest environmental law groups have strong teams working on access to justice, as Joanna has alluded to, for environmental matters, which opens the way for future legal action by a wider range of actors. So our lawyers have been engaged in a decade-long access to justice battle in the EU, and we had some really good success in July last year, where they succeeded in getting the EU to expand standing under the Aarhus regulation, which implements the Aarhus Convention in the EU. Previously, only NGOs could use the Aarhus regulation to challenge EU decisions, but even then they could only do that concerning in relation to individual companies. So following complaints from Client Earth, EU institutions then agreed to remove those restrictions, and that will allow individuals as well as NGOs to challenge a wider range of EU decisions. That progress that we've achieved with Aarhus also illustrates how important our advocacy work is to support environmental litigation and to create the right framework for accessing courts, because sometimes it can't be done through litigation itself. And other issues that we would consider that go to the need for systemic change as much as possible in the cases that we select, deterrence and precedent setting. So for example, in the Total action that I mentioned, that could change the regulatory landscape for net zero claims in the EU, given that it invokes the UCPD, the Unfair Commercial Practices Directive, which applies to all fossil fuel companies that are advertising net zero credentials within the EU. And finally, there are also practical aspects of selecting cases, and that includes things like making use of our in-house expertise as much as possible, finding suitable experts who aren't conflicted in matters, and also looking at the availability of in-country legal partners. So Client Earth itself isn't a law firm. We're an NGO with in-house lawyers. And so we work very frequently with partners in the countries that we're working, that we're bringing proceedings in, or that we're involved in proceedings where we're, so I won't go into any more details on those practical aspects now, but if you have any questions about that or any of the other things I've covered, please let me know, and thanks.
Thank you very much, Charlotte, for this great insight into how NGOs and specifically Client Earth is working, and congratulations on all the amazing work that Client Earth has been doing so far. Another friendly reminder, we already have a number of questions on the Q&A, but this will be your final reminder before we go into the Q&A. So I would like now to introduce our last speaker of the day, Dr. Chiara Macchi. Chiara is a lecturer in law at Wageningen University and Research Law Group in the Netherlands, and she's the author of a recently published book on business, human rights, and the environment, the evolving agenda. She has authored publications on climate due diligence, extraterritorial human rights obligations, and many other topics that are very relevant to our talk today. So without further ado, Chiara, the floor is yours.
Many thanks, Danilo. Let me see if I managed to share my screen. I have slides. Okay. Are you able to see them?
Yes.
Okay. So first of all, many thanks for the invitation and congratulations for organizing this event. I'm very happy to be here. And of course, I follow the work of Charlotte and Joanna closely. So I'm very happy to hear from them directly what they're working on. And today I'm going to say a few words about the emergence of a concept of so-called climate due diligence from the climate litigation that Joanna and Charlotte have already introduced. So as highlighted by Annalisa Savaresi and Joanna in their article, climate litigation, which has been on the rise in the last decade especially, has been promoted predominantly against public authorities so far. While the authors, so Annalisa and Joanna as well, they highlight that the number of cases targeting corporations is actually on the rise. This number is still relatively low, and even more so if we consider those lawsuits that have yielded a final decision. Because the available jurisprudence is still limited and fragmented, we are nowadays not able yet to draw decisive conclusions about a legal definition of climate due diligence. However, we can certainly observe the trends in litigation that help us identify its possible elements. Recent judicial developments coupled with legislative initiatives on mandatory human rights and environmental due diligence in particular are starting to give important indications to corporate actors on what is increasingly expected from them, in line with the Paris Agreement's recognition that achieving the temperature goals requires action by the private sector as well. In my article on climate due diligence, I highlighted that two main themes were emerging from climate litigation, namely there was an emphasis on risk mitigation on the one hand and on integration on the other. Risk mitigation is concerned with the reduction of greenhouse gas emissions in corporations' activities and projects, whereas integration refers to the duty of corporations to fully integrate climate-related objectives into their policies and processes. Now, starting from risk mitigation, Annalisa's and Joanna's article confirms that climate litigation still predominantly revolves around mitigation more than around adaptation or compensation. Of course, there are exceptions. For instance, the ongoing lawsuits in Germany by a Peruvian farmer against the electricity provider RWE contains both a loss and damage and an adaptation dimension. However, the prevailing trend so far has been to target big greenhouse gas emitters, the so-called carbon majors, based on their historically significant contribution to global warming, to argue that they should reduce their emissions or in general refrain from contributing to rights impacting climate change. There are several examples of this approach, such as the carbon majors petition referenced by Joanna before. This type of lawsuit, largely made possible by advancements in attribution science, entails several complex questions from the point of view of climate due diligence. One of these questions is if we accept that certain big emitters need to stop contributing to climate change, how do we quantify the required emissions reduction, and how do we define the reduction responsibility of companies in relation to the different emission scopes? The Milieudefensie versus Shell judgment in the Netherlands is particularly interesting in this regard, in that for the first time a court has mandated a cut in the greenhouse gas emissions of a corporate group. And of course, in doing so, the court had to devise a method to quantify such reduction based on available climate science, and particularly based on the reduction pathways presented by the IPCC. Now, the use of science in this judgment has been criticized, is still subject to debate, but from the point of view of carving out a concept of climate due diligence from the UNGP's notion of human rights due diligence, I find it particularly interesting to look at how the court distinguished between an obligation of result in relation to the group's direct emissions and an obligation of conduct in relation to the group's indirect emissions. The court is very clear in the judgment that the group's scope 1 emissions must be cut by 45% by 2030. However, in relation to indirect emissions, it affirms not a duty of result, but a best efforts or due diligence obligation to reduce the emissions produced by the group's business relationships and end users. The court does not elaborate in detail on this distinction, which, however, resonates with the UNGPs, I would argue. Indeed, this differentiated approach to direct and indirect emissions resonates with the strict responsibility of corporations under the UNGPs to avoid causing or contributing to human rights harm, versus their due diligence responsibility to seek to prevent or mitigate the adverse human rights impacts that are directly linked to them by their business relationships. The due diligence responsibility to try and influence the conduct of third parties under the UNGPs is conveyed through the concept of leverage. In the case at hand, the court did not mandate the specific avenues that the company should follow to exercise such leverage, but it did note that Royal Dutch Shell will need to influence its end users' emissions by adjusting the energy package produced and sold by the group. And it also suggested that RDS might decide not to make new investments in explorations of fossil fuels. Now, it is to be hoped that other ongoing cases will further help shed a light on how climate due diligence should be interpreted. For instance, in the case Notre Affaire à tous and others versus Total, brought under the French law on the duty of vigilance, the plaintiffs seek a court order mandating the company, among other things, to take steps to align its own activities with the Paris Agreement's goals. In a paper that I've written with Nadia Bernas, we have reflected on the fact that if such an alignment is to be realized, then certain principles underpinning the Paris Agreement should feed into the definition of climate due diligence. In particular, the principles of progression and of highest possible ambition underpinning the Paris Agreement seem at face value incompatible with what we may call retrogressive measures taken by companies, meaning incompatible with all steps that halt or reverse progress towards realizing the temperature goals. An example of such steps could be, for instance, investing in exploration for new oil deposits. It also means that progress towards the goal must be based on concrete and measurable targets that should clearly emerge from a company's policies. And indeed, looking at climate litigation, it is clear that, as mentioned at the beginning of this presentation, climate due diligence is not only about reducing emissions, but also about fully integrating climate change into the company's due diligence plans, as also requested by the plaintiffs in the Total case, for instance. This requires, first of all, considering climate impacts in the company's impact assessment. And the Dutch NCP, in this respect, in a final statement concerning ING Bank, found that it was a responsibility of the bank to identify the methodologies to assess and disclose its direct and indirect emissions, even in the absence of international guidance in this domain. The importance of considering climate change as an integral part of the environmental impact assessment of projects is also emerging from litigation against public authorities. Moreover, as highlighted by Annalisa's and Joanna's analysis of the so-called just transition litigation, it should be kept in mind that human rights and climate objectives do not necessarily align. Projects intended to facilitate the energy transition, like wind farms, for instance, might harm human rights. For this reason, it can be argued that already at the stage of the risk assessment, human rights, environmental, and climate risks should be considered in a coordinated manner with due regard to their interactions. Another clear due diligence expectation that emerges from litigation concerns the way companies communicate about climate change, and this has also emerged from the previous presentations today. This responsibility entails a positive obligation, a positive duty to disclose the climate risks identified by the company and the steps undertaken to address them. This is, of course, in line with the UNGPs, but it is also in line with the OECD guidelines, which specifically encourage corporations to disclose accurate information on GHG emissions and work towards their reduction. However, climate due diligence also entails a negative obligation to refrain from actively preventing action on climate change by misleading the public, for instance, in order to undermine public support for greenhouse gas regulation. And in the slide, I've put some examples of lawsuits in which these aspects have emerged. Now, as mentioned earlier, an exhaustive definition of climate due diligence cannot be grasped from the case law currently existing, in part because this is still in its infancy and quite fragmented, but also because climate due diligence, like due diligence in general, is a flexible concept whose exact content depends on the specific risk profile, characteristics, and context of a company's operations. For sure, some guidance could come from emerging legislation, as it is already the case in France, and of course there are high expectations on EU-level legislation. As concerns the treatment of climate change responsibility in the EU or draft directive on corporate sustainability due diligence, sorry, I have already expressed some reservations in other recent talks, so apologies if you will hear me repeat myself on this issue. And let's start by saying, first of all, that the draft directive is a groundbreaking development and that the inclusion of a climate change dimension in it is to be saluted as a great achievement. The draft directive contains a provision, Article 15, requiring member states to mandate the adoption of a plan to ensure that the business model of in-scope companies are compatible with the limiting of global warming to 1.5 Celsius degrees. Companies that identify climate change as a principal risk or impact of their operations must include emissions reduction targets in their plan. Article 15, however, does not provide any guidance as to how the prominence of such risk is to be assessed. or as to the due diligence implications of scope 1, 2, or 3 emissions that we have seen is an issue that has been addressed in the recent Milieudefensie judgment. Also, the climate change responsibilities of companies under the directive seem to be treated separately from the general environmental and human rights due diligence requirements. Of course, the legislative process is still underway, and more clarity might come in the future from accompanying guidance documents. But at this stage, I think the current text of the directive does not go as far as it could in affirming that climate due diligence is a dimension of human rights and environmental due diligence, and that the related processes should be integrated as needed, especially in key due diligence phases such as the risk assessment or stakeholder consultations, for instance. Finally, let me briefly recall that climate litigation should also be read not only in the context of these legislative developments, but also in the context of important developments in the realm of business and human rights litigation more generally. And I think I spotted Dan Leader in the public, so he's one of the authors of these developments. Now, in Milieudefensie versus Shell, the court, without formally lifting the corporate veil, found that the policy setting influence exercised by the parent company, Royal Dutch Shell, over the group's companies entails an obligation to ensure that the group policy is concrete and targeted enough to realize the reduction obligation that rests on the Shell group as a whole. This finding largely resonates with recent case law in the UK, and particularly the Vedanta and Okbabi judgments, establishing that the parent company's duty of care might arise from the group-wide policy frameworks it set in place and by its public commitments as well. So as I conclude in my article with Josephine van Zeben, this trend in litigation makes it increasingly difficult for parent companies to hide behind the fixio juris of the corporate veil, and requires them to take responsibility for the social, environmental, and climate change impacts of their subsidiaries' activities. And I will stop here, and I will be happy to discuss further in the Q&A. Thank you very much.
Perfect. Thank you very much, Chiara, for the great presentation on your article and also the topic of your book.